Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court. Be seated.
Good morning. Before we call the first case, just a brief reminder to anyone, attorneys or parties who will be arguing this morning, that it is being live streamed. So if you have a case, I think I believe our first one is a parental termination case, try to avoid using children's names in it, refer to them some other way if you can. Court's open to the public, but we'd rather not put that much information about children by name out to the world if necessary, unless necessary. Okay. Call the first case, please.
In re Hope G. et al.
We'll hear from the appellant.
Good morning, Your Honors.
Good morning.
May it please this honorable court, I'm here for the father, who is the appellant, of course. The issues are rather simple and straightforward.
Counsel, do you want to reserve any time for rebuttal?
I do not.
Okay, that'll be fine. Go ahead.
The issues, as I say, are very simple and straightforward. There was, at trial, there was what I would submit to you a lot of noise that did not address the core issues. There were allegations of a drug addiction, of drug abuse, never much in the way of proof which would impact the issues of termination and adoption. There was talk about head injury from a traffic accident, but never any proof that that affected any parenting abilities or had anything to do with the issues of termination and adoption. So what I do think, and what I urge the court to rule, is that the real issues here center around the father's failure to visit. This is not a case, as the court sometimes hears, where there is what would be termed token visitation. There was no visitation by the father whatsoever in the 4-month period preceding the filing of the petition. What the proof revealed was that the mother had forbidden the father from seeing the child. There were issues raised at trial about the credibility of my client. Credibility is not even an issue because both sides agreed that this is what happened. The mother stopped the father from seeing the child. She called it a pause. It was a pause, a never-ending pause, a pause without end. She admitted in her testimony that she had never told the father that the pause was over and he could see the child again. She never told the child's great-grandmother, who was really more of a grandmother figure to the child, that the pause was over. She never told the father what he had to do to satisfy her and therefore end the pause. When the father did file a document in the Greene County Juvenile Court seeking to have contact with the child again and for the court to establish a new parenting plan based on the situation as it existed at that time, the mother was in just a few days, and before the juvenile court could rule, filed a petition to adopt and to terminate the father's rights. So,
Counsel, excuse me for interrupting. In this case, was there an agreement between the parties with respect to co-parenting time that may not have been filed or submitted with the trial court?
This case was mediated some years ago. The parties reached an agreement, and for reasons that I won't go into, the mediated agreement was never made a formal order of the court. Nevertheless, the parties went by the schedule that they had agreed upon in mediation.
Was that a written agreement?
It was a written agreement.
Is it part of the record in this case?
I don't recall if it is or not, Your Honor.
Thank you.
I did not look at that. I apologize. But they had their own method of dealing with visitation issues. They had their own method of dealing with support issues. And while it was not ideal,
Counsel, let me ask you about the support. That was one of the grounds the trial court found was abandonment by failure to support. Is that correct?
Yes.
Is there any dispute that, I mean, what do you say about that ground? Trial court found that your client was receiving money from Social Security for the benefit of the child and never paid any, certainly during the 4 months.
It relates to the question, Your Honor, that we were just addressing. They had their own way of doing the support issues, and what they had been doing prior to the mother terminating the father's time with the child was the mother would provide receipts to the father for what she was spending on the child. The father would give her money in the form of support. And while no court is ever going to impose that upon a parent, that's the method they chose to deal with it. At some point, the mother stopped providing receipts and the father stopped providing support.
So there's no question. I mean, you talked about your client's credibility. You said the trial court wasn't very favorable as far as your client's credibility, correct?
Correct.
And, for example, you said your client, as I recall, testified that, I'm putting that money in an account for the child. And the trial court said, well, show us some proof. And well, I've got it in the car. Fine, we'll take a recess, go get it out of the car and bring it in. And he still produced nothing, correct?
That's correct.
So there's really, I mean, is there any dispute that he didn't pay anything during those four relevant months?
There's no dispute that anything was paid.
Okay.
And that in fact nothing was paid. The dispute comes when you look at his reasons for not paying and the facts that surrounded that, which had to do with the mother's unilateral actions. And so when we filed in the juvenile court, he had, I think the testimony was that he borrowed the money from his grandmother, the child's great-grandmother, to pay attorney fees and court costs on that. And there was testimony introduced, and I know in the appellee's brief, the situation is talked about in terms of that the father had extra money, but the proof was, the transcript is devoid of proof beyond to meet the clear and convincing standard that would show that he had the ability from his Social Security check to pay support.
Well, the burden was on him, wasn't it?
Well,
to prove that he,
yes.
lack of willfulness.
Yes.
And the trial court found he didn't prove it.
You're correct. And one of the mother's contentions at trial was that the father, if he had things to complain about, should have taken the matter to a court of competent jurisdiction much sooner than he did. It's our position that by her unilateral actions of stopping his visitation, stopping his parenting time, that it didn't automatically shift to him to bring it to a court of competent jurisdiction. She could have also taken things to a court of competent jurisdiction, but she never did. She didn't even file a petition for adoption or termination until he filed his action in juvenile court. So hers was only a reaction to what he filed, and it was for a very clear purpose to make sure that the thing she called a pause was in fact permanent. And so he doesn't believe that she should benefit from not taking actions. One of the things she testified to was that going back to spend time with the father would create a risk of substantial harm to the child, either physical or emotional or both. But she testified that she never sought counseling for the child. She never sought any other professional help for the child to deal with this. The proof is devoid of anything that would say that she fostered a good relationship with the father for the child to have. She simply got the father out of the child's life, out of her life primarily, and then that was the end of it. So we believe that it all stems from her unilateral action stopping the child from visiting with the father. She could have easily taken that to court, got a ruling, got some professional help. The court would have, in all likelihood, addressed the issue by ordering some counseling to help with whatever problem existed, but she didn't do that, and we don't believe that she should benefit from her failures and then claim that the father's failures is the reason that we're here. So quite a bit of the trial was spent on the issues of the best interest of the child. Just because we are in big orange country, I'm not going to come in here and try to convince you people that these walls are orange. And I'm not going to try to convince you that the issues of best interest of this child was handled egregiously by the trial court. In all frankness, I think any court would have ruled the same when presented with all of the evidence as this court ruled on the issues of the best interest of the child. Our point that we would urge the court to strongly consider is that it should have never gotten to the point of whether any proof was even necessary as to the best interest of the child. We will concede that if it were solely based on best interest of the child, the father would not prevail. I don't think I could stand here and be honest with the court and tell you anything else, but I can tell you that should have never gotten to that issue. I'm reminded of my own raising of children. I tried to do the best that I could in raising my children, but I can tell you quite honestly that I saw times when I thought that person over there is a better parent than I am. I was fortunate. My children turned out very well despite my mistakes, but I can't tell you that I would win all the arguments about who might be the better parent, because I don't think I would have won all those. I think I would have lost a few and maybe one more than I lost, but it shouldn't. It's not that simple, and that's not the only issue. Had it not been for the mother preventing the child from being able to see the father, none of those issues would ever matter to the court. So quite frankly, we submit that most of the other things that you will read in the transcript is simply noise and doesn't have much to do with the issues of termination, which obviously precedes the adoption. We did not have any evidence to present to the court concerning the adoptive stepfather. And if we had such evidence, we would have presented it. But so it's not about that either. It's simply about the mother's actions in stopping the father from seeing this child, and the things that happened all after that all stem back to that one action. So with that, I have nothing further to add, Your Honor, unless you have questions.
I hear none. Thank you.
Thank you.
We'll hear from the appellee.
Thank you, and may it please the court. I'm Crystal Jesse from the Greene County Bar, and I represent the mother and the stepfather in this matter. And we've successfully, I believe, won at court, at the trial court level, based upon the factors of abandonment. I also brought forth the G14 factor and cited two cases, I believe, in which Justice Davis had previously written opinions that are on the same wavelength that this case is in this matter. In this case, it's simple. We have a father that has just never followed through. If you look at the file, this case came about originally in 2014 when the father filed his petition to legitimate. The parties went to mediation and came to a temporary agreement that was never codified or was never transcribed and signed off on by a court. So we have from 2014 up until September 20th, 2019, the father was having every other weekend visitation supervised by the great-grandmother. Now, I say that very liberally in that their agreement was every other weekend, but the court credit the child's testimony in that she did visit with the great-grandmother every other weekend. The father did live with the great-grandmother at that point in time. However, the father spent 5 hours with the child on that every other weekend. So even prior to taking the pause, he had token visitation at best. Then in September of 2019, 2 incidents occurs. The first one in which the father got into a physical altercation. The child had to call her aunt that lived in Greene County and her sister to come pick her up. The child was hiding under a table at that time, and I have notated this on page 3 of the brief. The next weekend visitation, which would have been approximately 14 days later if we're doing every other weekend, the father gets into another physical altercation with the grandmother and the girlfriend. At that point in time, the child went and hid in the bathroom and called her mother, who in turn called the stepfather to go pick her up. From that point forward, my client did have a pause. The child did not want to go back. The child testified she did not want to go back. However, from September 2019 until December 2nd, 2020, the father did nothing. He did not call the child. He did not file to see the child. He did nothing. He filed December 2nd, 2020, trying to enforce an agreement that was never before the court in an order to begin with. My client then filed for termination and adoption of 3 of the children, and one of them, of course, is in front of you today, and I will not name her name or initials, RMG. The problem is, and the last time I was in front of your honors before COVID, I was arguing In re Bryson F, and the mere filing alone you found is not sufficient. He had to do something. He never actively pursued anything. He stated that he tried to call the child, yet in depositions, if you notice, I asked him, pull out your phone, and then I asked him to call the mother, and the phone rang. He said the mother had him blocked. He said the grandmother said the mother had them blocked, yet the mother and the stepfather and the child, all 3 testified they never had them blocked from calling. The child had her own telephone, yet the father never reached out to her. Then we go forward as to the failure to support.
Well, before you move off from the failure to visit, so there's no dispute that the mother ended the visitation. She called it a pause.
Yes.
Is there any dispute that she never notified father that pause is over?
No one ever asked. There was no ordered, but no.
I understand. So she basically tells father, you can't visit, and she gave her reasons why. So, but never told him that, okay, you can start visitation again.
No.
All right,
Nor did
so
he
the
ask.
pause I'm just trying to get, so the pause continued.
Yes.
Till he filed what he filed, and then your client filed the petition to terminate.
A year and 3 months later, he filed. He never asked what he could do. Neither did the great-grandmother ask what they could do. I believe it's their duty, especially when he doesn't have a formal order legitimating nor a formal order for visitation. It was his duty to come forward. He did nothing, as I said before, for a year and 3 months. Then we move on to the failure to support. I do not think it's devoid, and specifically, if you notice in the record on page 4 of the transcript, I asked in depositions when he was living with his mother how much his specific bills were. He said $470 a month. Then at trial, it was $1,160 a month. He gets a Social Security benefit of over $1,500. Again, in the last case I was here was In re Bryson F, where Social Security alone, being on disability, is not sufficient enough to waive his duty. He had discretionary income. That $1,500 does not include the child's portion he was receiving. He received $660 a month in 2018, $678 in 2019, and $680 in 2020. During the period of time, he had ample money.
From Social Security.
From Social Security. Yeah. He had ample money. Opposing counsel argues that they had this system. Well, the system was if the mother needed money early on, back in 2014, to probably 2015, she would send him a text and say, you have to pay for the cheer. That system didn't work when she had to pay the insufficient funds because he would write a bad check. He knew he had a duty to support the child, and he did nothing. Again, this is a gentleman that has not followed through. Additionally, I brought up the third ground that the court did not find, and I cited to Justice Davis's cases, and that is the G14 prong. Specifically, in Ray versus Ray, the court set out, of course, I do not believe the father showed a manifestation of ability or willingness to obtain custody because he's done nothing. And then in the second prong, and I highlighted it very specifically on page 16 of the brief, is there a real hazard or danger that is not trivial, minor, or insignificant, and the harm must be more than theoretically possible, sufficiently probable. And then I went on to cite in the N. Ray Virgil W. case, again, where you all wrote, and specifically Justice Davis found that the father's visits were just not good visits. He would take the child and hide from the police officer. So that was sufficient to find sufficiently probable to find that harm would exist. It's theoretically possible. In my case, we go even further. The harm's not theoretically possible. It is actual. The last 2 visits there, the child was harmed. She was in the middle of 2 assaults, had to hide, one in which the father was arrested. So I believe the court erred in not finding the ground for the divorce being, the ground for termination being G14, applying to this case. With that being said, and since counsel did not argue the best interest factor, I will waive and sit down unless you all have any other questions about the grounds for adoption and termination.
I hear none. Thank you.
Thank you.
Our court's thanks to counsel for both sides. We appreciate your briefs and your oral arguments in this.